Yeah, thank you, my Lord, for giving me the opportunity. My Lord, if you listen to the submissions made by the applicants, especially the application by the firm of Musyoki Mogaka for Gabriel Van Straten and Ita, you get the feeling that they have not understood the purpose of this petition. You also get the feeling, and on this one I join issue with my senior colleague Murgor, that it appears they are not happy with the decision which has been made. And it also appears, and they stopped from denying this very fundamental fact, that they have been filing proceedings elsewhere at the Public Service Commission. Proceedings which are before this court, before your brother Justice Macau, to remove DPP in this matter because of certain decisions DPP has made, which they have completely misunderstood, and they continue to regurgitate in their submissions as a ground for participating in this matter. You also get the feeling that they have no idea that the legal system ventilates their rights. So they want to rush to these proceedings, which are targeted, thinking that their rights as victims and as witnesses are completely closed. My Lord, at the very center of this matter is the murder investigation of the late Tob Cohen. My Lord, this investigation has taken more than 15 months. It took more than 15 months before eventually the Director of Public Prosecution found that there was no evidence to charge my client, the petition. My Lord, at the center of this case, in fact, my Lord, this case starts and ends here, is a letter of 9th of June, 2021, which is annexed as annexure number...
Give me the date of the letter.
9th June 2021, from the office of DPP, and it is signed by Victor Mule. It's addressed to the Inspector General of Police. It's annexed as annexure number JG1 to the supporting affidavit of John Gashomo, Senior Assistant Inspector General of Police, the one which is on record, and it's sworn on 27th September 2021. So in this particular letter, my Lord, the DPP has expressly, clearly, and unequivocally indicated in a 5-page analysis that upon review of the DCI file in this investigation, and the entire basis upon which DCI recommended the charging of the petition, having evaluated all the aspects, including the motive which Mr. Issa now brings back here. Mr. Ita has cited 3 motives, brings back here in this application. The DPP has said and concluded, after debunking each and every allegation, including motive, that there is no evidence to charge there is no sufficient evidence to prefer criminal charges against the Honorable Sankali Olekantai for the murder of Tob Cohen. We therefore direct that the inquiry file should be closed with no further police action. Then the DPP says the duplicate inquiry file is returned herewith. Well, that letter is very significant because it appears that everybody, including Ita and Gabriel Van Straten, are not happy with the decision of DPP. But DPP again has said that there is sufficient proceedings, there is sufficient evidence to charge two suspects, Sarah Wairimu and Mr. Karanja, sufficient suspects to charge them. My Lord, there are also applicants in this matter. They want to participate in these proceedings. My Lord, DPP has then subsequently charged them in the High Court for the offense of murder. So, my Lord, two major questions arise. My Lord, ordinarily, my Lord, I make this admission. Ordinarily, my Lord, if you examine the nature of petitions, ordinarily, this is a petition where these interested parties have a right to participate. Ordinarily, they have a right to participate. Indeed, the entire jurisprudence of joinder of interested parties in a petition would ordinarily require that they participate in these proceedings for the reason that their names have been mentioned by the respondents. By the respondent, my Lord, in these proceedings. Ordinarily, my Lord, that will be the case. And one can really make that concession for purposes of illuminating the issues. My Lord, however, this is a matter where the court is required and inclined to exercise absolute and maximum restraint. My Lord, and in accordance with the rules, the Constitution of Kenya, Protection of Rights and Fundamental Freedom and Practice rules, this court is required to make a proportionate decision. My Lord, proportionate decision meaning it must balance the issues and consider that, for example, the clients represented by Senior Counsel Philip Murgor and Mr. Mbati are already charged in the High Court, in a court of competent jurisdiction, by a judge who has cognitive abilities to sieve through the entire evidence and make a decision whether they are guilty of murder or not. My Lord, it may well be, if you look at the entire application by Philip Murgur, it may well be, my Lord, it may well be that the DPP and DCI wrongly charged Mr. Karanja and Mrs. Wairimu as claimed by themselves. It may well be that is the case. Indeed, in the entire application by Philip Murgor's client, he's saying the decision is false and malicious, that the decision is flawed and baseless, and upon the review of the entire evidence in this matter, his client is innocent. And I believe the same trajectory is being adopted by Mr. Karanja in his application. They're saying they're innocent. It may well be they're innocent, but we never know. But the opportunity to prove their innocence, I submit, is not this petition. the opportunity to prove their innocence, where they can attack the motive of the investigation, they can attack the issues, they can go deeper and make submissions. For example, they can adopt the approach and say, my lord, the glove does not fit. We want our clients to be acquitted. In the famous statement from O.J. Simpson's murder trial. Well, they can say that, but my lord, this is not the forum for them to do that. My lord, it's a basic and fundamental principle in criminal law. And my lord, especially on this particular matter, my lord, if you look at the affidavit of Martin Nyaguto and the affidavit of John Gashomo, and the analysis by BPP as contained in that letter of 6th of June 2021, it is crystal clear, especially if you look at the affidavit of Martin Nyaguto, Assistant Superintendent of Police, where my colleague, my lord, the affidavit is sworn. This is a very important affidavit, my lord. It is sworn on 3rd of November 2021. In that particular affidavit, I hadn't seen it before, but I've looked at it in the context of preparing this matter. My lord, there is a witness statement by Mr. Dunstan Omari Mogaka, who is an advocate appearing in this matter. If you look at that witness statement which he wrote to the DCI, he provides the background information which, according to DCI's affidavit, lays basis for the murder. It provides that context in which the late Tom Cohen was murdered, because it narrates one-on-one discussions which Mr. Tom Cohen had with Mr. Dunstan Omari, an assault. Apparently, there was an assault which were reported at Gigiri and Muthaiga police stations by Ms. Wairimu and Mr. Tom Cohen. And then he concludes. So it is, in my view, provides some kind of a basis, the context, which might fortify the DCI's case for purposes of prosecuting the first interest, the second interested party. So there's some kind of a basis, Malo, a reasonable basis one can conclude. And therefore, the conclusion one can then make is that the DPP's decision to make that recommendation should be respected and not subjected to collateral attack in these proceedings. Collateral attack in these proceedings. If they are innocent, as I submitted earlier, they will be acquitted and they will go home and they will sue the DPP and DCI for malicious prosecution. But to attempt to raise those facts here, those tribal issues in this particular matter, will directly be a collateral attack of the criminal proceedings. And that is why we are saying that this Honorable Court is supposed to make a completely proportionate decision. My lord, let me also admit that it is unfortunate, it's indeed unfortunate, and my client too has been dragged on this. It's unfortunate that the affidavit by John Gashomo was published extensively in the media. Social media and all that are submitted by my colleague, Senior Counsel Philip Mulgur and Mr. Mbati. It's very unfortunate, I have to say that. It's very unfortunate that an impression has been created in the media, and which also touches on my client as well, that they have participated in the murder. But my lord, we are a country governed by the rule of law. My lord, we have a judicial system which is functioning, which is seized of this matter. My Lord, as I submitted earlier, I believe the learned judge handling the murder case has the sufficient ability to discern evidence from an allegation to make a decision which will meet the ends of justice for both parties. So despite that wide publication, we verily believe that this matter will be handled appropriately, and any triable issues which they have, let them raise it in the trial court. It's not enough, really. It's a basic requirement, my Lord, in the law of crime as I submitted. It's not enough to come in this petition to raise these triable issues. My Lord, what is this petition all about? My Lord, this petition is a targeted petition. A targeted petition. And that's why, my Lord, we are submitting that this honorable court shall exercise some restraint so as not to go to the issues. Understand Philip Murgol's client's predicament. They have dragged him in this matter through a replying affidavit. They have dragged his client in this matter, and I understand that predicament. Understand Matthew's predicament. They have been mentioned adversely in this particular affidavit. But the correct legal position is that that matter is before a competent court. And therefore the court must exercise absolute and maximum restraint and make that proportionate decision so as not to interfere with the factual findings in the criminal matter. Because a conclusion by this court on the facts which are pending before another court of competent jurisdiction will be extremely prejudicial and quite problematic and highly problematic. Indeed, it will undermine the integrity of the proceedings in that trial court. Because, my Lord, all that will be done, if you make a ruling concluding on the facts, is that they will show up in the trial court and say that even a judge of competent jurisdiction has made a factual finding that we are not guilty of murder. That there is reasonable suspicion that we are not guilty of murder. So, my Lord, I urge that you restrict yourself to the petition at hand and not make any adverse, even though the entire application, my Lord, the entire application by Mr. Murgol's client and Mr. Mbatia and the other parties scream and they invite you. My Lord, these applications are screaming and they are inviting you to make a conclusion. Of course, in response to their client's rights, having been mentioned by Senior Assistant Inspector General of Police John Gashomo. My Lord, I urge that you exercise restraint. Again, I have to mention that it's very unfortunate that Mr. Gashomo had to swear that affidavit. Really unfortunate on a matter which is pending before another court. But, my Lord, in this matter, exercise restraint. Don't make conclusions on the affidavit, on the factual issues that Mr. John Gashomo has made. Because it will be so problematic in the entire trial process and it will undermine the criminal process. I'm saying that because, as submitted earlier, this is a targeted petition. A petition which raises a single complaint. My client, the petitioner, the petitioner, the learned judge, has not made any allegation about any of the interested parties. None at all. He has not made a single allegation about Mr. Anway Rim. Not one. Mr. Anway Rim, sorry. Not one. He has not made a single allegation about Mr. Karanja. Not a single allegation. He has not made a single allegation about Gabriel Van Straten and Mr. Ita. Miss Ita. What is before this court is a simple petition on whether, based on the DPP's letter of 6th of June 2021, the Director of Criminal Investigations made a fundamental mistake in arresting the judge and charging him in court sorry, my lord, arresting the judge and attempting to charge the judge in court. Indeed, a charge sheet had already been prepared in accordance with the affidavit of John Gashomo to charge the judge on a matter where there is no evidence whatsoever to charge the judge. If you look at the petition is restrictive. It is seeking those kind of declarations that, first of all, arresting the judge and bringing the judge to court, attempting to bring the judge to court on a matter which has not been the subject of complete investigation. The petitioner is alleging that is wrong. They should have at least asked him to record a statement before arresting him. That is one of the complaints in the petition, a targeted petition. Number two, the petitioner is seeking in this petition an order that there was no reason whatsoever to lock him in police custody before completing investigation. Thirdly, the petitioner is alleging that they should have had the courtesy of informing him of the reason for the arrest in accordance with the provisions of Article 29 and 49(1) of the Constitution. Another question which the petitioner is seeking redress in this petition is a simple one, that confiscating his phone and then taking data in that particular phone without his consent in the circumstances of this case is a breach of the Constitution. A targeted order. And based on the DPP's letter clearing the petitioner, the petitioner is saying, I shall not be arrested by DCI again on this matter unless DPP has said so. It's a simple request to make. Clear checks and balances in the criminal justice system. DCI, the petitioner is alleging, has gone rogue. And he's saying, why can't you make decisions that respect the authority and powers of DPP in the Constitution? And then lastly, the petitioner is seeking a permanent injunction to restrain the DCI from arresting the petitioner on the facts of this matter. And my lord, DPP has also said that there is no evidence. If there is additional evidence, and my lord, you can take this petition to the extreme end. My lord, if there is additional evidence, my lord, if evidence is adduced now, my lord, if additional evidence is adduced now to convince DPP that there is reason to charge the judge, my lord, can this court issue an order to stop the charging of the judge? It can't do that. So my lord, you can clearly see that at the heart of this matter is the decision of DPP to say that there is no evidence to charge the judge with the murder with the offense of murder and related offenses. And my lord, we have the authority of Stanley Munga Githunguri versus the Republic, where, my lord, the decision of DPP to charge or not to charge a suspect.
My lord, with your kind permission, I think my mind is not agreeing the petition.
No, my lord, I'm not arguing. I'm responding to the first issue. It's really, I'm not arguing the petition. I went to the prayers to demonstrate the fact that my colleague who represented the estate of ITA went to the prayers and said that this prayer is about ITA. I just was making a distinction that the prayers in the petition is not about ITA. But I want to...
Ms. Mwanga, are you hearing me?
Can you hear me, my lord?
Yes, I'm following the argument so well, don't worry. If he steps out, I will definitely raise a red flag. I'm following it closely. Proceed.
Yes, so my lord, the authority of Stanley Munga Githunguri versus the Republic In this particular authority, it's a 1985 case. My Lord, the summary of this authority is that the decision of DPP whether to charge a suspect or not shall be respected. It's a constitutional discretionary power. And if that power has been exercised, like in this manner, in favor of our client is lawfully entitled to file a petition to question the manner in which he was arrested and dragged before the cells at Muthaiga and then continuously harassed for more than 10 months. That is the sole purpose of this petition. So it is a targeted petition. It's not a petition where the interested parties, the orders which are going to be issued by this court will not affect the interested parties at all. None of the interested parties will be affected by the orders of this court. Because the orders are exclusively restricted to the petition. My Lord, some of the interested parties, like Gabriel Van Straten, I concur with my colleague Joseph, my colleague from the firm of Mugoka Musyoka, who cited the case of Joseph Lendrick Kwaswa and versus the Republic. It's actually a Supreme Court decision, petition number 23 of 2019. It's a Supreme Court decision on the rights of victims to participate in a murder trial, So in this case, I make the distinction that Gabriel Van Straten is not precluded at all to participate in the proceedings in the trial court as a victim of this murder. She's not precluded at all. She has every right to cross-examine witnesses. She has every right to participate, of course, through counsel, to participate in the proceedings. And that's what the Supreme Court has said. The Supreme Court has not said that a victim of a murder can participate in a constitutional petition where the decision to charge a suspect or not has been made. He can't participate. So it is a basic and fundamental principle of law that Gabriel Van Straten's rights have been protected. This petition does not in any way seek to preclude her rights, but the proper forum for her is to participate in this in the trial court. What stops her from raising all these questions in the trial court? She can't be allowed to turn these proceedings into an attack of the decision of DPP. My Lord, I submit that if Gabriel Van Straten is not happy with the decision of DPP, the most and logical thing to do is to file a separate constitutional petition attacking the decision of DPP, saying it's unconstitutional. Then the court will examine the exercise of that particular power against the documentation and determine whether DPP exercised that power capriciously, maliciously, or not. The simple issue. So they have remedies under the sun to follow. This is not the forum for them to do that. All the complaints which my colleagues submitted about that Gabriel Van Straten is a sister of the deceased, that there's an issue about property, that they have lost a dear brother. All those are issues that shall go to the trial court's record, not this court. Again, Miss Ita is a witness. Miss Ita is a prosecution witness. in the trial court, together with Gabriel Van Straten and Mr. Dunstan Omari. So they have every right to participate and lodge their facts in that trial court, how they perceive the issues to be. They will be examined, cross-examined, and then the trial court will make a conclusion on the factual findings. For example, if the shares were transferred or not, fraudulently and all that, these are issues for the trial court, for the suspects who have been charged. If at some point DPP feels that my client should be a party in the criminal proceedings, DPP will make that decision if there is available evidence. And when that decision is made, then the interested parties, Gabriel Van Straten and Ita, who are witnesses, they will testify in court. So at play here is the integrity of the proceedings in the trial court. Parties who are coming to this matter and raise very key facts about matters which they're supposed to address in the trial court should then be told this is not the proper forum for you to do this, because it will heavily prejudice the DCI as the investigator. It will heavily prejudice the DPP as the prosecutor. If this court makes factual conclusions on matters which are before the trial court. So on the contrary, the interested parties will not be prejudiced at all. If they are told, sorry, this is not the forum for you, the forum for you is in the trial court, this is a targeted petition that the petition has filed, let's hear the petition without your involvement. The applicants cannot set a case. All the applicants, if they are participating as suspects in the criminal trial, they are participating as witnesses in the criminal trial, they are participating as victims in the criminal trial, they cannot use this matter to set a case for themselves. They can't do that. They can never be allowed to do that. Because this honorable court will be called upon to make conclusions on matters which are pending before a trial court. Matters which the trial court has not yet determined, the trial court has not yet ventilated, matters which are sub judice, as it were. I agree it is a grave matter, my lord. Someone lost his life. It's a grave matter. Tom Cohen lost his life. But my lord, the mere fact that the matter is grave does not mean that we sacrifice procedure that is at the core of the criminal justice system. And interfere with the judicial proceedings which are elsewhere before a court of competent jurisdiction. So my lord, public interest, which this court should rank first in time, will definitely require that rule of law considerations take effect, that the judicial system be allowed to work to its conclusions. So my lord, on a petition like this, which is a targeted petition seeking specific orders on a matter which the DPP has made a decision on, it then makes a lot of juridical sense to submit that whereas, and in conclusion, to submit that whereas in the ordinary petitions, the interested parties will have every right to participate in these proceedings. Whereas in normal proceedings, they will have that right. There are situation-sensitive facts and matters in this dispute that will warrant this honorable court not to exercise its discretion to admit those parties in this particular matter. All these interested parties except the DPP who has already been admitted by consent. The second proposed interested party, third proposed interested party, fourth proposed interested party, and the fifth proposed interested party. For the simple and clear reason that these persons are suspects, 2 and 3 are suspects in the trial court, they have been charged. 4 is a victim in that murder trial, and they have every right to participate. And the 5th one is a witness. So, my Lord, you can see where I'm coming from, my Lord. If you make any conclusion here on these facts, it will definitely interfere with those criminal proceedings. And I urge, my Lord, that whereas Mr. Philip Mulgore is right, his client has been mentioned so many times in this matter by DCI. The only thing that the court can do is to say, sorry, it's very unfortunate they mentioned you, but when determining this petition, we are going to determine it based on the facts in this petition so as not to collaterally attack proceedings in another matter before the High Court. I also understood my colleague, Senior Counsel Mulgore, in my last submission, to state that he has made certain applications before that particular court on the conduct of DPP DCI. He's making a lot of submissions in his application here that the trial is malicious. There's no evidence against the client and all that. And I understand he has made an application also to that effect in the trial court. I don't know whether it's the trial court, he can clarify that in his reply. But if it is the trial court or another high court in a separate proceeding before another high court judge, then it will make sense even more that this court should exercise absolute and maximum restraint. And by doing so, they are not being denied justice. They are simply being told that the clock of justice works in a particular way. So in conclusion, I submit that my colleagues haven't made a case for joinder. Instead, they have made a case where they are raising fundamental triable issues which the trial court is supposed to consider. They have made a very strong case for victim rights, which the trial court will also consider. They have also made a strong case in terms of the facts, which the trial court will consider, because one of the persons who seeks to join here is a witness, Ms. Zita. So if indeed she believes that was the motive of murder and DPP has charged 2 suspects for that, then the trial court will consider that and her testimony, and it will make a decision which considers all the facts. So I raised my submissions and urge that you disallow those applications.